It's time for the Financial Crisis Talk Center with Ken Gross and David Einstandig from Thav Gross.
Credit card debt is number one. I view it as financial cancer.
40% of your gross income is going to just pay the debt service. You got no chance of getting out.
I would give up my credit score to get rid of debt.
Here's your host, Ken Gross.
All right, welcome back to the Financial Crisis Talk Center. We've got Cait Maihot with us today from Gold Star Law, special guest in the studio. Good morning, Cait.
Good morning.
Glad to have you. Brian Small, co-hosting. David Einstandig's off this week, relaxing in the sun in West Bloomfield, Michigan.
Good morning, Ken. It's wonderful to be here this morning.
All right, we're going to talk employment law, workplace issues for this segment, and then the next segment we're going to talk about bankruptcy issues with Brian, but not the normal stuff Brian always jibber-jabbers about. We're going to talk about...
I jibber-jabber?
Yeah, you're a jibber-jabberer.
Is that a word? Jibber-jabberer?
Yes, it is. It's a new word. We're going to talk, in that segment, we're going to talk about questions people have about what happens if I file bankruptcy rather than bankruptcy per se. But now I want to go to employment law issues, because Cait, Gold Star Law, you are one of our sponsors on our show from the very beginning. We're also good friends. We've known each other many years, and you guys specialize in employment law issues.
Yes, we exclusively represent employees in employment law issues.
So this is the situation where people have issues in the workplace. It's, well, someone gets fired, they're going to call you. If there's sexual harassment going on, all sorts of issues that come into play.
Absolutely.
We see it all the time. So we've kind of worked out a couple questions to ask and then in little scenarios, and we're going to analyze them together. Cait's going to kind of walk us through, and Brian and I are going to kind of pose questions and see what we can do. It's not like this isn't cross-examination, though. But although cross-examination is kind of fun. All right, here's the situation. We're all going to work on this together. You apply for a promotion at work. You're working. There's a job posting for promotion. You apply for it, but the position is given to someone less qualified for you, less qualified than you, in your opinion. Now, you've applied for the job. You know the stuff. Some rookie comes in, or it's not a rookie, it's someone else, and they get the job, and you're scratching your head saying, what the heck? I was trying to think of what the word was. What the heck is going on that I didn't get that job? So what possible explanation? So, Cait, walk us through. Could race come into this issue?
Yes, if you were not given a promotion over somebody else because of your race, that's a violation of Title VII. Title VII prohibits employers from making employment decisions on the basis of race, color, religion, sex, or national origin. All
right, so let me ask on the obvious side, if I was African American and I didn't get the job and the person that was promoted was Caucasian, I could say, well, I'm certainly a protected class as African American. What about the reverse? I'm Caucasian and I'm more qualified, and I see that the supervisor gave the promotion to an African American who they were buddy with. Do I have a potential claim there?
Well, if you weren't promoted because of your race, then yes. I mean, you don't have to be any particular race to have a case for race discrimination. But you made an interesting point. If it's because they're buddy, that's different. Nepotism is not illegal.
Oh, so it's okay. And that's why Bobby Kennedy became Attorney General when JFK was president.
Maybe. I don't think anybody thought it was because of his race.
I mean, somebody may have objected, saying, I was more qualified to be Attorney General, but you gave the job to Bobby Kennedy.
It was his brother.
True. That was you weren't around then, right? I mean, were you even around? Were you there? Were you here?
No.
Okay, well,
I wasn't even a glimmer.
I was only in first grade, so it wasn't like I wouldn't have a great expectation that you were around. But it was a very controversial move, and nepotism. That's where I learned the word nepotism, was when Bobby Kennedy was appointed Attorney General.
So what you're telling me, and so I understand this,
is that you can be nesposic.
Oh dear God, you and the English language. So nepotism is acceptable. It can have the appearance of racial discrimination, but if it's because, hey, he's my good buddy, and I like him better than I like you, I can give the job to whoever I want, regardless of race, origin, whatever. That's not a problem.
Right. There's no legal requirement that a private employer promote the most qualified person regardless of their own personal feelings or thoughts or opinions. He just can't make the decision because of a protected status.
Now, you just said a private employer. What about a governmental unit?
Well, Title VII applies to the government as well. There may be some additional rules with governments prohibiting nepotism, but generally when you're looking at what's my Title VII action here, what can I sue for, you have to be in a protected status if you're claiming discrimination.
So it kind of comes down to a fact issue, though. So if I'm the employee and I feel as though I've been discriminated, I can get a lawyer to pursue the claim. The employer then has to defend it. Now, one defense could be, I made the decision not based upon the qualifications of any of the employees. I just wanted to appoint my nephew because I like him, because he's family. That would be a good defense.
It would be...
if the jury bought it.
If the jury bought it, sure, that'd be a legal defense. If you're only promoting all of your buddies and it turns out that they're all of the same race or all of the same religion, to the disadvantage of everybody in a different race or religion or something like that, it's going to look a bit suspicious. But if that really is your reason, that's not discriminatory under Title VII.
So how does an employer, from the employer side of it, protect themselves when they're making a decision like that?
I tell you, they should have a written policy supporting nepotism. I'm being facetious, but when we talk about that, it's a difficult situation for employer. This is what you're getting at, is if I'm representing the employer and I say, yeah, you can appoint your nephew, but that doesn't mean that you're not going to get sued under Title VII and spend $100,000 defending the case. So you have to be careful even... And Cait's always looking on the employee side. We sometimes are on the employer side. Sometimes we're on the employee side. It depends. The employer has to look out for ways to justify their action. The game plan isn't to win the lawsuit. If you're the employer, the game plan is not to get sued. That's what's important. Unless you're General Motors or some big company, I'm not picking on General Motors, but if you're a big company that's used to getting sued, like Walmart's always getting sued, no big deal. Just what's another lawsuit to them? They have the defense budget. But if you're a small business and you get and Gold Star Law comes after you, let me tell you, you got yourself a serious problem because you're going to spend a lot of money defending that case, and you're going to have to deal with it. You can't just say, well, I hired the person from nepotism, dismiss the case. It's not that simple. Big problem. What do you think about that, Brian?
I think it is a big problem. That's why I was asking from the standpoint of an employer how one resolves that.
Then you were asking a good question.
Indeed it was.
We're coming up to take a break. We're going to come back after the break. We're going to do another quote of the day. Then we're going to do special announcements, and then we're going to come back with more questions. We've got a couple more scenarios to work through of issues in the workplace. We'll be back after the break.
Are you struggling to pay your mortgage? Afraid of foreclosure and the financial mess it can cause? Time is not on your side. Call Alan Stalter, the short sale specialist. For years, Alan has been helping distressed homeowners navigate through the short sale process. His experience will get you out of your home without the credit score damage that follows foreclosure. If you want a fresh start, you need to call Alan Stalter, the short sale specialist, 248-854-3829 or MetroDetroitShortSale.com.
No one ever thinks that a serious injury can happen to them, but it can, and it does. And it can happen to you. And when it does, you need a fighter in that courtroom for you. Call me, Ben Johnson. Automobile accident, police misconduct, medical malpractice, product liability. You know what you're up against, how hard it is to get answers. When all you want is justice, call me, Ben Johnson. Whatever your legal crisis, I will fight for you. Call me today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem.
Going from hourly to salary seemed like a good career move, but now you're working 60 hours a week instead of 40, and you aren't getting paid any of that extra time. You're stuck, right? Wrong. You can be on salary and still be entitled to overtime. If you've been wrongly denied such pay, you may be entitled to that and more. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
All right, welcome back. We've got Cait Maihot from Gold Star Law with us today. We're talking about employment law. Brian Small's in the studio on bankruptcy issues, actually, and we're going to cover that more in the next segment. I want to do a couple quick announcements. We have a seminar coming up on February 25th, How to Eliminate Your Debt and Build Wealth. It's from 7 to 8:30 p.m. at our offices over at 12.5 Mile and Telegraph. We've expanded the seminar from last year to cover new topics. We have Brian does a nice lecture and spot on budgeting as well as student loan issues. If you look at what's going on in the marketplace now, student loan debt is becoming probably problem number one among the youths of the country.
I define
youth liberally because I'm older.
It's not just youths. I mean, student loan debt is affecting people in their 20s, their 30s, their 40s, people that have gone back to school, believing that they're going to be able to be,
just so you know,
get better jobs when they come out of school, finding out that $100,000 for the student loan debt doesn't get you that job that pays it off. And now what can you do?
When we first introduced it on the show, Eric Berlin, our youngest new associate, was in the office. He's a young lawyer. He graduated last year. He's in his first year of practice. He's doing a great job. He's got like $130,000 of student loans or something. I may have the wrong number, but I thought that's what he said.
It's a tremendously large number. It's an uncomfortable number for
you
all
go in there
students.
Thinking you're going to come out of school with a $150,000 job, and you find out, not quite available anymore. It's not the roaring 2000s. It's the puttering 2000s is what we have, particularly in some markets.
One of the things that the seminar is going to provide is strategy to deal with all of these issues. And we go in depth, and I'm certain that everyone who will come to the seminar will get a strategy to deal with their financial situation.
So if you want to sign up for it, you go to our websites, thavgross.com, financialcrisistalkcenter.com. There's a little click there. You click on seminar, you enter your information, we mail the tickets to you. Seminars are well attended, and people really enjoy them. It's an hour and a half, questions and answers after. You get your questions answered. It's kind of an inspiring kind of a process. People enjoy them.
Easy sign up on the mobile app that's on your smartphone, too. FCTalkCenter.com will get you right there.
Yeah, our websites are now smartphone adapted, so that we have on both websites you can use those. And we also have added a new thing, the Financial Crisis Debt Analyzer, which if you go to that, you enter in. This is something I worked on for 3 years. It's finally out there, and people are using it frequently because I'm getting a lot of the reports back. You enter your information in there. It evaluates your information from the standpoint of loan mod, short sale. Would I be good to settle my credit card debt outside of bankruptcy? Would a Chapter 13 bankruptcy work? Would a Chapter 7 bankruptcy work? How do I deal with tax problems? All those things get analyzed, and you put in your data. You get a free report, get instantly emailed to you to look at what your options are. Doesn't cost a penny. All the data that you provide is confidential. So if you want to check that out, go to the financialcrisistalkcenter.com website. It's right on the center of the homepage. I want to thank our sponsors, Venn Johnson Law, Gold Star Law. Cait, thank you for the continued support. Samasco Law, Double Action Shooting Range and Gun Shop, Spine Specialists of Michigan, Elite REO Services, Alan Stalter, Short Sale Specialist, and coming on board shortly, Cardiology Associates of Michigan. All right, so back to workplace. Enough with the housekeeping matters. Let's go to another question on the workplace. Okay, I'll give you. No, actually, stay with the same thing. We didn't. I don't think we covered everything. What about attendance issues? If you're, if the employer says to you, "I didn't promote you because you have a lousy attendance history," what about that?
Well, depending, of course, on why you have that attendance history, it's generally okay. It's legal to use that as a factor. If you're just always late because you wake up late, because you don't anticipate traffic, if you just are no-call, no-show all the time, it's perfectly legal for an employer to make a decision based on your attendance record.
I mean, I would think as an employer on that side of the coin, I would think that would be certainly rational. When would attendance, if someone has poor attendance, when would that be excused?
Well, probably the most common situation where you see attendance being protected is when you're looking at FMLA. The Family Medical Leave Act allows qualified employees of qualified employers to take up to 12 weeks of unpaid leave in a calendar year or in a 12-month period for qualified reasons. If you've taken FMLA, your employer can't retaliate against you for exercising that right. They can't say, "I'm not going to promote you because of your attendance," when the attendance issues are protected leave.
So like under the leave. But if you've got someone who habitually just can't make it into the office on time, and they're always a half hour late, and they walk in the place like there's a cloud around their head, that's not going to be protected.
Generally, no. There are some circumstances where it could be, if there's some sort of disability
handicap
and a reasonable accommodation, be letting them come in late. If you allow other people to come in late and not them because of some sort of discriminatory factor where you hold the attendance policy to them differently than other people.
All right, let me ask you a different one.
Wait a second. What size employer does the FMLA apply to? How big do you have to be, or how small?
You have to have 50 employees or more within a 75-mile radius.
Okay, so that would exclude most small businesses.
Right.
Depending on how you define small, but yeah, I would agree with you.
Yeah, employers with less than 50 employees do not have to give FMLA leave to their employees.
No family FMLA leave for you, Brian.
No, there won't be. No, I'm sure of that.
At least not for a while, anyway. What if the reason the employee is rejected is because the employer's having a relationship with the employee promoted? Not nepotism. He's sleeping with the employee.
Right. It's a very interesting situation.
Going all the way out there on the relationship just so that everyone understands what the issue is. Allegedly.
Generally, that's just another form of favoritism. Favoritism is not protected.
So having an affair is kind of like nepotism, I suppose.
Yeah, it's just a form of favoritism. But some situations are a little different. If the employer says to an employee, if you do this, if you have this relationship with me, you'll get a promotion, that's absolutely illegal. That's sexual harassment.
Sure, okay. Thinking about that, I'm just stepping back. If you're having a relationship with someone in a nepotism relationship, that could be very illicit, just as a side note. Think about that while we go on to a break. We come back after the break. I'm going to give you a different situation. The employee starts a job as a waitress, and see what happens step by step in that relationship and what claims attached to it. We'll be back after the break.
You like your job. What you don't like is the way your boss has been treating you. He's making comments about how you look instead of your work, and he's been touching you inappropriately. If you complain, is he allowed to fire you? Absolutely not. Unwelcome sexual comments, advances in contact are illegal in the workplace. Make him pay. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
Every family has the family meeting, and we all know what that means. Dad's got dementia. What are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call because I can do it for you.
Double Action, shooting center and gun shop for the largest selection of guns, accessories, and ammunition. Double Action is your only pro gun shop. And now you can train with the best in our basic CCW course with the most comprehensive curriculum, the best resources, and most accomplished staff. Don't be fooled by cheap imitations. Double Action is the only place to get your CCW or renewal. Double Action. We're on DeQuinder and Madison Heights.
Do you have tax problems, unfiled returns? Facing levies on wages in your property? You need an expert, not a cartoon character or salesman. Thav Gross is your solution.
You need to look at the big picture. That's what we do. We develop a plan that's right for you.
I had major tax problems. I didn't know what to do.
You need to address the problem now. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
All right, welcome back. We've got Cait Maihot from Gold Star Law. We're talking about employment issues. I'm going to give you a scenario, and then we're going to analyze it. A little spicy one for you. Okay. Woman goes to work for a restaurant as a waitress. It's owned by a married couple who manage the restaurant together. The husband keeps trying to kiss the waitress, the new employee, and asking her for sexual favors. Now, obviously, this is not going on in front of his wife. But the employee rationally is repulsed, I'm adding a little bit to the story, and rejects him and asks him to stop every time. No, please don't. Little acting there. Finally,
acting.
The employee, I'm going to get sued for harassment because I'm elaborating. No, I'm kidding. Finally, the employee talks to the wife, and the harassment stops. So she rats out the husband. It says, your husband is groping me. Can you do something about it? Now, this isn't a situation where the wife takes a 5-iron to the husband. That's a different story that was told a couple years ago that became... I'm just exaggerating on that. But obviously the wife's mad. She talks to the husband. As a result, immediately after this complaint is filed, the harassment stops. Husband gets word, figures out he better stop it. But she's told she has to work an extra 8-hour shift every week, putting her at 48 hours per week work, and her only additional compensation is the extra tips. So so husband who's running the show is now putting the waitress in a slavery mode from the standpoint of working as a way of retribution. She works the extra shift for a few months, then complains about not receiving her overtime compensation. After she makes that complaint, boom, she's canned. She's fired. So what do we have here? We've got this is what I would call the hodgepodge of claims.
Right, but it happens. This is actually almost identical to a real case that we're litigating right now.
Do you know the name of the restaurant?
I do know the name of the restaurant.
But we're not going to know it here.
Right.
Okay, good. Okay, give us a rundown on claims. Is there a sexual harassment claim here?
There is. There's a sexual harassment claim because there's a hostile work environment. The harassment is severe and pervasive enough to offend a reasonable person. And importantly here, the employer is what we call on notice. The harasser is an owner or manager of the restaurant. She's asked him to stop. The employer is aware that the harassment is unwanted.
So in that case, that brings to an interesting issue, a hostile work environment. Obviously, if the employer is the harasser, it's almost, I would think, per se, a hostile environment. What if it's a co-worker that's harassing the employee?
Right. See, an employer can't be held accountable for harassment that they don't know and have no way of knowing about. If a coworker is harassing you and you don't tell your supervisor, you don't tell your HR, your boss doesn't walk by and see it, if they don't know about it, they can't be expected to stop it. You need to make a complaint.
So once you make the complaint, then they kind of have to investigate?
Right. Then they have that's when they're on notice.
But in this scenario, you had the employee complain to stop. Mm-hmm. And it stopped. So where's the cause of action?
Well, if it had been a coworker doing the harassment and the employee complains and then the harassment stops, you don't have a cause of action because the employer was on notice. The difference here is that the harassment came from somebody who's, synonymous with the employer. It's the owner, it's the manager. And so he knew all along that the harassment was unwanted. He had a duty to stop it. He was on notice, and he's somebody who she could have complained to if it were someone else, and that would be notice.
So
where does it go?
He's got liability for harassment.
I understand. Where does it go? The employer makes a harassing attempt to make a pass at the employee, and the employee says, "Get away from me," and it never happens again. It's a one-time event. Is there an actionable claim, or is it at that point only if it continues?
Well, if there's one attempt, it's really not a hostile work environment. It's not severe and pervasive. If the employer says, "I'd like to take you out on a date," the employee says no, that's not a severe and pervasive hostile work environment. You don't have any sort of claim there. Alternatively, if the employer tries to grope the employee or something like that, and the employee fights back, then it's clear that the harassment is unwanted. If that continues after the employer knows it's unwanted, the employer's on notice.
Sure. And then on that little side note, from an employer's perspective, the safe way is you don't need to be asking the employee out, period. Don't step into the pool and then you're not going to drown. As soon as you put that first little toe in the water, you're looking at potential problems. There's no upside to it.
Absolutely. Yeah. And if the employee rejects the employer's advances, and even if the employer stops at that point, there's always the fear from the employer's side that any sort of adverse action you take against the employee is going to look like quid pro quo sexual harassment, like I'm now demoting you or firing you because you rejected my advances, and that's illegal.
All right, we're running short time. I want to ask you a quick question right on this same topic. What about the overtime issue, Cait? What about that? What kind of claims come out of that?
Right, well, very interesting issue in the restaurant industry with overtime. First of all, the fact that they assigned her an extra shift that she didn't want, aren't paying her for it, right there, that's retaliation. They're doing that because she made a complaint. You can't take any sort of adverse action against an employee for making a complaint of sexual harassment. But regarding the overtime itself, you have to pay overtime. In the restaurant industry, for a waiter or for a waitress, even if they're on tip credit, you have to pay time and a half. And a lot of restaurants don't do that. A lot of restaurants think they're doing that, and they're paying the tip credit wrong.
Yeah, we were talking about it at the break. They're paying the tip. They're taking a time and a half benefit on the tip credit, which they're really not allowed to take. Is that what it comes down to?
Right. You can deduct a certain amount for a tip credit. So minimum wage is $7.40. But you can deduct a tip credit and just pay them $2.65 as long as they make up the difference in tips so that they're getting at least minimum wage for all hours worked. For overtime, time and a half minimum wage is $11.10. So you don't take time and a half $2.65, you take time and a half $7.40, and then you deduct the same amount as tip credit.
So there's a lot of claims there. So here's the bottom line. If you're in the workplace and you think you have a claim, the best place to find out about it would be to call Gold Star Law.
Absolutely. Then you don't have to figure out how to compute the tip credit on your own.
What's the phone number over there?
1-800-WAGES-10.
There you go. So if 1-800-WAGES-10, Gold Star Law. I want to thank Cait Maihot for being with us in this segment of the Financial Crisis Talk Center. We'll be back with another segment of the Financial Crisis Talk Center, and we're going to talk with Brian Small in that segment about questions people have relating to bankruptcy. Thanks for listening.